President Obama said he believed that the FISA court would benefit from the addition of a civil liberties advocate. He was somewhat vague at the time, but I took it as confirmation that he agreed that there should be a special advocate or an adversarial process more robust than what we have now. But the form of advocate he's endorsed, I think, can be improved, and I thank him for his very thoughtful attention to this issue. But I think that the advocate can be made more effective if we, in effect, give it a certain form. As I see it, the special advocate must, for example, be able to proactively request participation in FISA court proceedings and to engage the FISA Court of Review appellate process for significant legal decisions. That would be a real reform, not just a cosmetic tweak to the current process. Giving this power to the advocate herself rather than leaving it entirely in the hands of the court to invite an advocate on occasion when the court thinks it's important is very, very important. We've heard from the Privacy and Civil Liberties Oversight Board that at least some of the judges on the FISA court believe they already have the power to call upon third parties for alternative views, but they have never exercised that power. So giving them the option or the choice is ineffective, in my view. The structure requires the advocate to make decisions about when the opposing view should be presented. And that's also why I believe that the advocate should be a permanent position with an established office and a staff, not an occasional on-call observer status that the court hears only when it chooses to do so. And so my proposal would grant the advocate many of the powers of any counsel, assert factual and legal arguments, present them to the court, and take cases through the appellate process, much as appointed public defenders do now. They are available whether or not the judge thinks a defendant needs a lawyer when the defendant needs a lawyer. And this special advocate, some may call him a constitutional advocate, would have the responsibility to protect our rights and liberties whether or not the court thought it was necessary in that case, because courts may not appreciate the importance of issues when they arise, as Patricia Wald, a very distinguished jurist, said.